Yes! Hello, my beautiful friends. It is an amazing day. We're waiting for those tubes to fire up all across the fruited plain of the interwebs before we get started because we've got some serious business to attend to today. The clock is ticking. Sentencing for Trump scheduled for this Friday. Trump now knocking on the door of the Supreme Court to say, can you please stop this madness? This is lunacy. Alvin Bragg and Judge Merchan and the judges in the New York court's appellate system are all colluding to interfere with the peaceful transfer of power, crossing the legal line that's already been laid down by the Supreme Court of these United States. And so let's do a quick preview on what is coming up. We had an announcement shared over from Mike Davis from Stephen Chung, Trump's spokesman, who explained that Trump has filed an emergency petition at the Supreme Court, and there's already been an order from the court on this. But we're going to read through what the petition has inside. You can see 51 pages of deliciousness coming from Todd Blanche and Emil Bove saying, Your Honors, at SCOTUS, you have to stop what Merchan is doing, demanding a stay of the upcoming sentencing. So we'll see what Judge Sotomayor has already said about this, because she issued a response, and we'll have some more updates on that coming tomorrow. But simultaneous with this case, we're also in the 11th Circuit. You can see this docket is also jamming, and we're waiting for something to drop any minute because Trump's team has been ordered to respond by 5 o'clock today Eastern time. So we're waiting for something to come skidding in here on that. But two other items were filed. Walt Nauda's response and his request to stay this release of the Jack Smith fake book report, saying all that has to be stopped. Jack Smith is not a real boy. He stole $30 to $50 million of American taxpayer funds, and now he's trying to get the benefit of that, of being an illegal prosecutor, by releasing a bunch of sensitive information that he is not entitled to. And so Trump's defense, really Walt and Carlos de Oliveira, in conjunction with Trump, are now appealing in the 11th Circuit. And I've got several of those documents pulled up, including the government's response, where they're saying exactly what we predicted they'd say yesterday when they started doing this volume 1, volume 2 crap. Well, now they're saying they can bifurcate the two, release one, withhold the other, because Judge Cannon doesn't have jurisdiction over them. So all that's coming up. I've got clips from Pete Aguilar, who's a liar. So we'll see how he's lying today. And then we got Kinzinger, who looks like he's bloated, man. Wait till this pops up right here. Look at this guy. All right, come on, show us. Come on. All right. There it is. Look at him. I don't know what's going on, but he's not looking good. And so we'll be seeing what he's up to today, coming up very soon. And so we got a bunch of good stuff to get to. Very glad that you're here. Thanks for joining us. Thanks for subscribing to the show. Before we get into any business on the day, speaking of, being a little puffy after the holidays and wanting to get back into good health, well, one way we can do that is with our friends at Field of Greens, baby. They're back, and it's good because it's New Year's. Many of us are resolving to get healthier this year. Question is, how are we going to do it? Are we going to do supplements? Are we going to eat more fruits and vegetables? Or how about other green drinks? There's a bunch of stuff out there that you can drink these days. That's fine. Try what you want to try. But what if they're not promising you better health? Well, what's the point? If they're not promising you a result, well, maybe you shouldn't try it. But what about another offer that is 100% confident that they'll improve your health? Well, that's our friends at Field of Greens. They have a better health promise, and they make them radically different than everybody else. And so here's how it works. You enjoy a delicious Field of Greens drink each day, and at your next checkup, your doctor will notice your improved health, and they'll say, my goodness, you came like springing in here. How'd you do it? And if they don't notice that, you get your money back. Not the springing part, but your health. Now, how in the world can Field of Greens offer this better health promise? That's because every fruit and vegetable that's packed inside there focuses on a specific health benefit. We've got heart health, lungs, kidney groups, metabolisms, even healthy weight. One drink a day is all it takes. So you'll feel better, you'll have more energy, your doctor will notice that you look amazing, or get your money back from them. Just say it didn't work and get your money back. And so you can get your New Year's discount, baby. Use code Robert. Go to fieldofgreens.com That's code Robert at checkout, fieldofgreens.com, and get your delicious, healthy superfood today. And we appreciate Field of Greens for coming back and sponsoring today's show. All right. And so now, my friends, let's get into it because we got business to attend to, starting with this recent emergency filing from the president. President Trump goes to the Supreme Court with an emergency petition to stop Alvin Bragg and Judge Merchan from executing their sentence in just a day's time. We've got, this is what has been filed into the Supreme Court of the United States on application by President Donald J. Trump. And the sentencing has been scheduled for the 10th. Trump has already tried his appeals at the state court there in New York, gone up, they kicked it right back down. We were asking ourselves, what was the next step? Can he bypass those other state Supreme Court and just go right to SCOTUS? He's done it. Here's what he says. It's coming from Todd Blanche and Emil Bove, two gentlemen who have been long representatives of President Trump, who are going to be going into the White House and the Department of Justice. They've submitted this saying, all right, listen, SCOTUS, highest court in all of the land. This is an application to stop and to stay the criminal proceedings in New York. We are appealing this in the middle of the trial, in the middle of the proceedings. Trial's over, but sentencing has not happened yet. And Trump is arguing that he has immunity. And what is his authority for the immunity? The Supreme Court. He just won there. They said there is presidential immunity, which has been functional and obvious for 234 years until the Democrats decided to shatter all of that in order to prosecute someone they hate. So Trump is coming and saying, hello, you said that they can't do this and they're doing it. So can you please do something, please? Thank you. So here's what it looks like. These are the specific questions that are going up to the court. Question: is President Trump entitled to an automatic stay of criminal proceedings against him when he is in the middle of an interlocutory appeal? Question: whether the trial court's admission and use of official acts evidence during the trial violated presidential immunity, as you recognized in United States versus Trump. And finally, whether a sitting president's complete immunity extends to the office of the president-elect, which is where Trump is right now. So he's been elected. He is assuming the office, let's say, of president-elect. So does he get those same benefits, or can hack prosecutors like Alvin Bragg wreck the incoming presidency to the best of their ability, as long as they get the shot off before the shot clock expires? They got it in. Oh, good, it's good. It's fine. Is that how that works, Supreme Court? So you know who the people are. Obviously, it's the 47th president, who's also the 45th. And the respondents are Alvin Bragg and Judge Juan Merchan, the Khan, who is gagging the president on behalf of his corrupt daughter, in my opinion. Says, past the table of contents and the table of authorities, Trump's defense team submits this to the Supreme Court. 9 justices, highest court in the land. They say, all right, listen, guys, we've been through this for a long time. Now we're here. This application requests an emergency stay to prevent further criminal proceedings in Judge Merchan's court, including the sentencing hearing that's scheduled for this Friday at 9:30 in the morning, which we're going to be live streaming here regardless, in case some shenanigans happen. So thanks for subscribing. The hearing is scheduled against the president-elect of the United States at the apex of his presidential transition, 10 days before the inauguration, and after his electoral win has been certified by both houses of Congress, while he pursues a meritorious interlocutory appeal based on presidential immunity, which you confirmed exists. On Friday, January 3rd, the Supreme Court of New York wrongly denied Trump's motion to dismiss. That's Judge Merchan. He did it contrary to accepted practice, contrary to New York law, and to due process. And then he set the matter on the 3rd for criminal sentencing less than a week later, so that Trump didn't have any time to come to you, Supreme Court. And that's why this is so nefarious. Now, President Trump promptly filed an appeal, notified the trial court that it is subject to an automatic stay. You, Supreme Court, have said that's the rule. When you're bringing up immunity, you have to resolve immunity. You can't just say, well, we'll get to it later, but let me just make your life hell with criminal proceedings for a couple years, and then we'll talk about immunity after you've been bled dry. But the New York courts have erroneously refused to honor that stay. And so, Supreme Court, this court should enter an immediate stay of further proceedings in the New York trial to prevent grave injustice and harm to the institution of the presidency and the operations of the government. The commencement of Trump's appeals raising claims of immunity makes it an automatic stay. And we're relying on case law that comes from you. See this U.S. right there? That's you. This appeal will ultimately result in the dismissal of Alvin Bragg's politically motivated prosecution that was flawed from the very beginning, centered around the wrongful actions and false claims of a disgraced, disbarred, serial liar, former attorney, violated Trump's president's due process rights, and the crime had no merit whatsoever. Now, in the meantime, the New York trial court lacks authority to even sentence the president or to conduct any further criminal proceedings against him until we solve this question of immunity. Same point that was made. Even Judge Chutkan could figure this out, Judge Merchan. Now, as discussed herein, says Trump's defense, this court should order an immediate stay of all criminal proceedings against Trump, including but not limited to the sentencing scheduled for Friday. Now, if necessary, you should also enter a temporary administrative stay of those proceedings while you consider this formal stay application. So you may not have enough time to weigh this case on the merits, so just use your administrative power. But questions always come up. Can the Supreme Court do this? Can the Supreme Court do that? Yeah, they can do whatever. They're the Supreme Court. They do administrative powers, whatever. They just make it up and do it. Okay, it's the Supreme Court. So just use your administrative state proceedings to say, hey, we need a pause on this so you can't sentence him so we can review the question of the stay and the legal question about whether immunity would extend to a president-elect, or for example. And so you've got a lot of options here. Now, here's the statement to the Supreme Court from Trump's defense. They say the trial court erroneously admitted a whole bunch of garbage evidence. On March 30th, 2023, Trump was indicted by Alvin. The meritless case was tried before a Manhattan jury. On February 22nd, Alvin provided disclosure before the trial started of anticipated trial evidence. And we've included a bunch of that in our appendix to you. Now, this disclosure included evidence of Trump's official acts, things that he performed while he was in office of the presidency. Trump moved to preclude all of that stuff. He said, you can't. Those are my official acts. I'm allowed to do those things because the Constitution says so. In his motion, when Trump brought this up, Trump specifically challenged the admissibility of several bits of evidence, saying, I'm shielded. You can't use that against me. These included a bunch of things. His X account, Twitter account at the time, statements that he made as president to the media, documents and documentary evidence reflecting his official actions, orders and things, testimony of White House employees, and other actions that Trump actually did and took. They wrongly denied Trump's motion. They said, well, it's, timing. Your time was off, and so you can't file that now. The trial court declined to consider, Merchan's words, whether presidential immunity stops Trump. Didn't want to talk about it. Just like yesterday in his filing, he said, for the most part, I've rectified these issues. For the most part, what? You get marked down in grade school for that. Explain yourself, the teacher says. What are you talking? For the most part, you can't write that. Not as a judge. The trial court also rejected President Trump's request to stay the trial. Then in April, Trump filed an interlocutory appeal saying, I've got immunity. You cannot do this. New York's appellate courts don't care. In denying the petition, they reason that Trump's claims of immunity can be raised later in a direct appeal after the case is over, which is legally wrong. What good is immunity if you have to wait till you're in prison to claim it? On April 15th, the first day of jury selection, Bragg made an offer of proof involving official acts. He says, this is what I'm going to use against Trump at trial. Trump said, you can't do that, including why immunity, including the recently decided Supreme Court case. Then on April 15th, Trump again objected. Other objections to statements that were coming in as evidence. On April 19th, then, as the trial was about to be underway, Merchan said, I'm not deciding your objections. Okay, so we're just going to wait till trial because he didn't want to make a record on this. So I'll just deal with it at trial. And Merchan was being very sneaky here. He wanted to get things messy in the trial, knowing that the record becomes a lot more muddled in the middle of a trial. so he doesn't have to anchor himself in on anything that the Supreme Court could come back and hit him with. Trump's people say the court would not rule on those objections at the time, but would address them during the trial. And that's what happened. During trial, Bragg repeatedly brought in official acts evidence. It was evidence of Trump's X account. He was talking to the American people about matters of public concern. There were testimony there from confidential White House advisors. Hope Hicks was coming up. Madeleine Westerhout was brought out. There were evidence about Trump's involvement in federal investigations. Talk about the federal pardon power of the president. Evidence of government forms were submitted. He's allowed to do those things. That's his job. How can he be criminalized for doing his job? Now, in addition to raising his objections, and if you say those are not his, that's not his job, and he's immune from those things, you got to have some hearing on that. You got to present some evidence and come to an official conclusion. Judge didn't do that. Just allow this all to now come up in the middle of trial. Now, in addition to raising his objections in a pretrial motion, in a pretrial appeal, and at the outset of trial, he brought it up during the trial many times as well. That's 4 times. Objection, 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 objection. The trial court overruled them every time. Then we got verdicts, 34 counts. On July 1st, the court issued its decision, Trump versus United States, came back down after the trial was over. The court held that the president does have immunity. And so the timing, okay, Trump was already fighting. So the timing is interesting because Trump was already fighting the Trump case. The decision from the court came back down after the Merchan trial was over. And they raced that trial through so that they could beat the Supreme Court decision. That's why he accelerated it. Now, Judge Chutkan paused her case, which was the right thing legally to do, and allowed the Supreme Court to issue their ruling, came back down, and then dealt with it after that. Merchan did not do that. He ignored it all, said, I don't have to, and wanted to accelerate the trial because Judge Chutkan had her trial bumped out. And they were just trying to beat the Supreme Court. So they're working against the Supreme Court because they knew that everyone knew there was immunity, okay, except that moron Judge Ludwig doesn't know anything. Anyways, so this continues. Now, the court further held that presidential immunity protects against evidentiary use of official acts against the president. Then, as soon as that order came down, Trump came back and said, Your Honor, sorry, you blew it, Judge Merchan. You should have not had this jury trial happen. You should have paused the case like the J6 case in the federal courts were, but you didn't. So now you have to vacate the jury. You used official acts against us, and you should have decided that or had a hearing and come to an immunity determination before the trial occurred. You didn't. So then on December 16th, the trial court denied Trump's motion. The court wrongly concluded that all of the evidence that came out at trial was entirely unofficial and you don't get immunity. So the judge just decided both things right there, right in the middle of the trial. That decision, among others, was made in error. And if it is allowed to stand, Supreme Court is going to gravely undermine the American presidency as we know it. Then after that charade was over, Trump on November 5th won, reelected 47th president in a historic landslide victory. Once he was reelected, boom, he's president-elect of the United States from the period between November 5th to January 20th, upon which time he becomes the president. So what happened? On December 2nd, after the tremendous victory, Trump filed a motion to vacate the jury verdict, saying, I've also got now president-elect immunity. Trump noted that upon his inauguration, he's going to be completely immune from all process. Even the DOJ agrees. Trump also stated that the doctrine of sitting president immunity shields him during this transition because he's preparing to become the president. Accordingly, Trump sought immediate dismissal. Then right away on January 3rd, which we talked about earlier here, the trial court denied Trump's motion. In the decision, he acknowledged that a sitting president is immune, but you're not immune because you're only a president-elect. And so we can get you before the clock expires. The decision and order was issued on Friday afternoon, and they scheduled it for the following Friday on January 10th. Was it? I think it was. The order was on so a week later. That is at the apex of Trump's presidential transition period. It's 10 days out from inauguration. So what they've done is a catastrophic mistake. They denied Trump's motion in the late afternoon of Friday, January 3rd, and they sent sentencing just a week later, 10 days before the inauguration. So on Sunday then, they notified Bragg that he's going to appeal this, and they asked for a stay. But then on January 6th, the day that Trump's historic victory was being certified, all of New York colluded, and they denied Trump's official act immunity and sitting president immunity, okay? 0 for 2, you have none. So then Trump sought an immediate stay, and that's why we're here. We're filing in the New York Court of Appeals, the highest level there, and they're filing in the United States Supreme Court. And they give us some law here on what the basis for requesting a stay is. And they say we meet the standard. We think there's a reasonable probability that you're going to grant this request. This case satisfies the criteria for the rules to be met. Explaining that before this decision, you held, Your Honors, that if you appeal on immunity grounds, it automatically stays further proceedings. You've said that already. And you said that, and you confirmed the correctness of the holding that a stay is mandated. You explicitly held, Supreme Court, that a claim of presidential immunity is subject to interlocutory appeal before further criminal proceedings may occur. And that dictates that it must be stayed until it's adjudicated. And so what is happening, Your Honor, is the New York courts are indefensibly disregarding your clear order. You explained that the criminal process's safeguards, though important, don't alleviate the need for pretrial review. We're not going to take your word for it or let some judge just decide. And so the questions about whether a president may be held liable is subject to review before further trial court proceedings can occur. You cited a bunch of cases. This case reinforces your conclusion, and they're expending some time explaining what a great job you guys did making this decision. The prospect of imposing a sentence on President Trump just before he comes into office raises the specter of other possible restrictions on liberty. Here we go. Travel, reporting requirements, registration, probation, and others, all of which would be constitutionally intolerable under the doctrine of presidential immunity. Indeed, every adjudication of a felony results in significant collateral consequences for the defendant, regardless of whether they're in prison or not, right? Voting, firearms. Now, furthermore, the trial court's erroneous approach would deprive Trump of the immunity that this court intended exist for this position. As noted, Trump held that the case Trump held that the essence of president and presidential immunity is that you do not have to answer for the conduct in court. Okay, that is what immunity is. Forcing a president to defend a criminal case through sentencing and judgment, while appellate courts are still grappling with his claim of immunity, would force him to answer for conduct in court. You've said you cannot do that. Trump's reference to the threat of the Trump case, okay, it's in italics there, I should be more clear about it. Trump is not saying this. The case's reference to the threat of trial and judgment, your word, mandate a conclusion that presidential immunity violations cannot be ignored in favor of some rushed pre-inauguration sentencing. By insisting on holding a sentencing hearing of Trump while his appeals are pending, they're doing exactly what you guys warned against here, judges. They're depriving immunity of its intended effect. There is no immunity if this is allowed to happen. And you said there is immunity. So the fact that Trump asserts immunity against the evidentiary use of his official acts puts this right under the doctrine of the Trump case. Regarding their unconstitutional demand to admit official acts, which you said they can't do, even if this stuff is immune and is scrutinized, it's not giving you the immunity. It's undermining the power of that privilege. Now, moreover, the automatic stay that Trump seeks here is routine. This happens all the time. As the court has held in other related contexts, whether the litigation may go forward is precisely what the Court of Appeals must decide. That's from the Coinbase case, which they spent a lot of time on in the automatic stay portion of their argument. It is, in fact, common practice. We enter automatic stays all the time. And Trump, for the reasons we just discussed, is entitled to both types of stays. He's, first of all, appealing at an interlocutory level, and he deserves an automatic stay as a matter of federal constitutional law. All of that is going to be binding to New York courts based on the Supremacy Clause. And moreover, the stay that Trump is seeking on the sentencing is very consistent with New York law, too. It's common there. Their appellate courts routinely stay criminal proceedings all the time. Trump is invoking that authority, too. It is therefore wrong and, in fact, astonishing and improper that New York courts have denied President Trump the basic procedural protection that is routinely granted to other criminal defendants. It's almost like they're abusing their office. Now, to be sure, President Trump raises again presidential immunity claims after trial and before sentencing, because the two key developments on which they are based, which is the Supreme Court case and Trump's election, both of those occurred after the trial. That's why we're bringing them up. You came back down. We already lodged our objections 4 times and said, you have to stop this because we're raising immunity. The judge didn't do that. Then the Supreme Court came back down and we said, see, I told you so. And then Trump won the election in the aftermath. That's a lot of changes. But the fact that Trump is seeking an interlocutory review before sentencing doesn't undermine his demand for an automatic stay. If anything, it shows us exactly why we need a stay. As this court and others have emphasized, presidential immunity protects the president from the entire suit. It's not just various stages of the suit. It's the whole thing. Trump must be afforded the opportunity to litigate his claim on appeal before these proceedings can move forward ahead, because it's based on immunity, not some other issue. Okay, if it's another issue, if you're like, well, I think that evidence was improperly admitted but not on immunity, then the courts will say, well, you can deal with that on appeal after the conclusion of the trial and the sentencing. But immunity introduces this extra powerful force field. The president, in undergoing a criminal sentencing, it's the most extreme example of the president, quote, having to answer for his conduct in court. Again, using the Supreme Court's words, giving it right back to them, said, we're just asking you to do what you said we need to do. The New York court's insistence on holding a criminal sentencing before Trump gets into office are resolved. It reflects the justice of the Queen of Hearts. Sentence first, verdict afterwards. From Alice in Wonderland. Took me a minute. What are we reading right now? Now, in sum, the question, which is whether a president of the United States is entitled to an automatic stay, is a significant question. New York is in direct contradiction of the Supreme Court, and they're in contradiction of other federal courts as well. This warrants your review and an immediate stay of the trial court proceedings. Now, as we continue, Trump's team at the Supreme Court tell us what they're trying to do here, Your Honor, is contradict you. You're not going to like this. They say the two substantive questions here are as follows, and these are major issues. First, they repeatedly admitted evidence of Trump's official acts. This question warrants review because it is the opposite of what you said we must do. During the trial, Alvin Bragg offered evidence of Trump's ex-posts, talked about presidential conduct in that. And we know that the president is allowed to talk to the people. Now, even if the public communications solely address attacks on the president's conduct, that doesn't undermine their official nature. Okay, so even if Trump is out there like ranting about some hack journalist or whatever, it's still official. A public official's statements defending his character and reputation are well-known official acts. Even in Clinton versus Jones, his public denials of allegations of misconduct would fall within the outer perimeter of his responsibilities. Except Trump got sued for that when he was rejecting E. Jean Carroll's insane story. They sued him for like $100 million. Similarly, the D.C. court held that a congressman acted within the scope of his employment when he discussed his marital status in office during regular business hours. I wonder who that was. Now here, the trial court admitted tweets that the president made. Those are clearly official communications from his public office about matters of public concern. He's defending his reputation and his honor against scandalous lies. And they said, well, the tweets don't fit the mold because they were entirely personal in nature and they did not advance a policy concern or other public interest, said the judge, and allowed them to come in as evidence against Trump. He's allowed to make those communications, and having a president who is not attacked with slanderous lies is a policy interest of the public. That's why Trump is allowed to respond to them. Nah, it doesn't count. I don't want him in there. Now, this reasoning, they say, is in full violation of what you said, Supreme Court. These public communications are from Trump himself through his social media account. He routinely commented to the public about this. Those were clearly official actions of the president, and they cannot be used against him. Oh, we got a little typo here. When he communicated with the public on Twitter during his presidency, President Rump, oh no, someone's getting busted for that. Appointment just got revoked. Oh man. President Rump possessed actual authority to speak on the executive branch's behalf. I didn't even want to call attention to it, but I can't. It's on the screen. You can see it. So the trial court committed the same fatal error with respect to the testimony of the communications and with observations of it happens, okay? It happens to the best of us. By senior presidential advisors Hope Hicks and Madeleine Westerhout. They introduced testimony from her, which was invasive. They were trying to get into the inner operations of the Oval Office. The district court offered and the trial court admitted evidence of these White House advisors and their official communications throughout this trial. Hope Hicks came and testified. Madeleine Westerhout testified. They talked about defending Trump's reputation against the Karen McDougal interview. Hicks said, yeah, I spoke to Trump. I was the comms director. It was a major interview. We talked about it. We have to defend the White House's honor against lying journos. In addition, Alvin Bragg also offered, and the trial court admitted Madeleine Westerhout's testimony. She was special assistant in the Oval Office. The testimony from her was about Trump's work habits and Air Force One in the Oval Office and his conversation with Melania and all sorts of insane things that should never have come in. The admission of this evidence directly violated what you, the Supreme Court, ordered. You said, what the prosecutor may not do is admit testimony or private records of the president or his advisors probing the official act itself. Allowing that sort of evidence would invite the jury to inspect the president's motivations for his official actions and to second guess the propriety of the president. And they're not the president. They don't get to substitute their judgment for the president's. Liz Cheney doesn't get to sit in her fake committee and say, Trump should have gotten up. And she does that stupid 3 hours, he sat there watching the news. Okay, Liz, relax. He doesn't have to do what you would do in a situation like that, which what you did in that situation has probably been on the team of the people who caused it. Trump would never behave like that. But as that constantly comes up, this is what the judge is doing. Well, what was he doing here? What was that payment for? What was that official act for? And if you allow that to happen, it's going to happen constantly. Every single person, well, let me get into your brain and say, oh, that's corrupt. Oh, that's corrupt. And we have a separation of powers and a supremacy power here. And so that cannot be allowed. Second guessing, Supreme Court, would threaten the independence or the effectiveness of the executive. Trump's defense continues saying at the Supreme Court, indeed, special considerations control when the executive branch's interests are implicated. While interacting with Hicks and Westerhout, Trump's staff, Trump was supervising people who were working for him. That is absolutely immune material. Holding prosecution with those communications would chill the president from doing those things, and you're not allowed to impinge upon that. We also have other evidence that should have never been admitted. The trial testimony of convicted perjurer Michael Cohen also brought in a whole new slew of violations. Cohen testified that Trump told him about an FEC inquiry that would, quote, be taken care of by Jeff Sessions. Now, even if that conversation happened, which is not conceded, never happened, what he's talking about is official acts. Even if it's bad, right? It's official acts. And so you have to then come to a determination about whether that is immune or not. You can't do that on the eve of trial after you've already prosecuted somebody. The district attorney also brought in testimony from Cohen suggesting that he was seeking the power of the president. And Robert Costello came in talking about back channels and communications to the president, talking about pre-pardons for Cohen and Costello. Cohen was saying that Trump was willing to use the pardon power, right? Cohen was throwing all this stuff around. Cohen was talking about executive power and all of those things. He's allowed to use his executive power. But the point in here is not necessarily justifying what Michael Cohen is claiming. He's a liar. All of his claims, in my opinion, start out in default as a lie. And then they've got to come back and show that he's a credible person. He just changes his story constantly. But the subject of the conversation is about official power, which means you can't bring that in as evidence, at least until you've gone through another type of a hearing that the Supreme Court has articulated for us, and you determine that that is immune or not immune. That never happened. In another instance, Cohen sought to justify his prior lies and his perjury, saying there was no Russia, Russia, Russia. Vitally, Trump's public statements in response to the special counsel were part of his official power. The presidential power includes the authority to, quote, engage in the hurly-burly, the give and take of the political process between the legislative and the executive branch. Other cases have explained this as well. All of this is absolutely immune. At least if they're not absolutely immune, they're at least within the outer perimeter and they're entitled to presumptive immunity. But at trial, didn't matter. The district attorney presented evidence of a 2018, when Trump was president, text message from Michael Cohen saying that Trump approved Cohen addressing an FEC complaint. All of that, and that Cohen would be able to make public communications. All of that, right, would be within the outer perimeter at least. And so it shouldn't have come in unless you could rule, if it's absolutely immune, it's not coming in. If it's presumptively immune, then the government has to overcome that burden to show it is not immune, and there needs to be a finding on that. The judge just did that at the conclusion of trial because he wanted the evidence to come in. And it's clearly absolutely immune, so it was an erroneous ruling. Now, during the trial, they also admitted evidence about government forms, right? Ethics forms that Trump is filling out and completing as part of his official business. The trial court said, well, a lot of people are required to fill out forms in their own official capacities, and it doesn't, and what Trump did does not render it within the outer perimeter of his authority. They say this is just wrong. The president speaking to the American people about public trust, that qualifies as official conduct. According to the Office of GE, one of the purposes of the form is to ensure confidence in the integrity of the government. That's what Trump was signing it for. He was speaking to the public trust, and it was an official act of business of the presidency, so you cannot talk about it. Now, considering all this overwhelming evidence, the trial court also wrongfully found that even if all the evidence constituted official acts subject to presidential immunity, which it did, that they were harmless. So he's like, well, I kind of know that those were official, but it was harmless error. First, the errors were far from harmless, especially considering the prosecution used their official acts evidence in their closing arguments. And second, this court, the Supreme Court, explicitly rejected the notion that as applied challenges in the course of the trial protect the presidency. In other words, that we don't trust the court, the judge, to protect the executive branch in the middle of the trial. Well, the judge is just going to make sure that nothing bad happens to the president. That's not good enough. So that's not harmless error. All parties agree the sitting president enjoys absolute immunity from criminal, state, or federal prosecutions. And now the question is, what about now? Like other aspects of presidential immunity, sitting president immunity binds state and state court prosecutors from prosecuting against the president. And because federal prosecutors may not charge or proceed in any way against the sitting president, it follows logically that state prosecutors may not do so either. The New York court erred, though, in holding that this immunity provides no protection to a president-elect. On the trial court's view, state prosecutors and state courts may charge or even imprison the president-elect during the critical transition period. This is obviously indefensible. It contradicts all of the logic and the authorities that say we have sitting president immunity. We also have the Presidential Transition Act. They say that the transition activities are crucial in Congress. So all officers of the government are supposed to take appropriate lawful steps. Okay, they're saying, look, not only does the Constitution have this inherent immunity embedded into it that Trump has that was violated, but Congress, so immunity applies to the presidency, we've determined that, should also apply to the president-elect, and Congress is also supporting that claim through their words in their legislation, where they said that we should all take lawful steps to minimize disruptions like sentencing a president. Many authorities recognize this sensitive time. And similarly, the structure of the Constitution and the separation of powers, they come to the conclusion that the president-elect is completely immune from criminal charges. That's why Jack Smith dumped both of his cases. First, the actual imposition would make it physically impossible, right? If you imprison a president, can't do their job. Same is true of the president-elect. But the trial court's position says that they could. Yeah, they actually could imprison the president-elect and release him at 11:59 a.m. on Inauguration Day. Moreover, it's like, man, try it. Now, moreover, any criminal sentencing and even the distraction of ongoing proceedings will continue to disrupt the enormously burdensome and sensitive tasks of the presidency. In just over 10 weeks between the election and the inauguration, we're taking over 140 agencies. You better believe it. And crucially, Trump must immediately begin addressing the most sensitive areas of national security, classified materials, national security, major military operations, covert plans. The complete engagement is necessary for national security. And there's also public stigma here. They're going to call him a felon now after the country just elected him. We're supposed to be on the same team. You guys tried everything you could to bleed out the Trump campaign with your criminal lawfare. You lost. And now you're going to be a sore loser and try to bleed out the winner. You're going to have to live under this country for the next 4 years. You played your hand, you lost. So just call it. But they can't help it because that's not who they are. Now, once again, the same reasoning applies to the president-elect. During the transition period, he's got to talk to world leaders, formulate his agenda, select key personnel. President Trump has been doing all of these things. Now, sentencing him on Friday's insane. And the mental and physical barriers, although they don't impact Trump at all because he is a human superhuman, these demands and times and energy are disruptive and annoying. Now, notwithstanding all these authorities, the trial court concluded that Trump has no immunity at all, and you're going to be sentenced on Friday whether you like it or not. The trial court relied on a case-specific analysis. They imposed their own tendentious view. Tendentious. All right, hang on a second. You know what time it is. Tendentious. All right, we're going to have to check it out. Make sure we're pronouncing this right. Okay, here it is. Turn to your neighbor and say...
Tendentious.
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 Tendentious. It means expressing or intending to promote a particular cause or point of view, especially a controversial one. Turn to your neighbor.
Tendentious.
All right, tendentious in the house. Okay, so back to the filing. Man, that was a serious word there. Now, imposing its own tendentious views from Judge Merchan and erroneously concluding that appearing for a criminal sentencing before his inauguration would not be too burdensome on President Trump. Now, that analysis is wrong because it dramatically understates the burden, disruption, stigma, and distraction that this case is threatening and already threatening to impose on his administration. Now, moreover, if the trial court imposes sentence on January 10th, Trump's going to have to pursue a series of criminal appeals during his first term, and we might even have to get remanded back down to this crap court for another hearing. A situation that presidential immunity squarely rejects. And more fundamentally, Your Honors, at the Supreme Court, the trial court's analysis from Judge Merchan contradicts everything, including the OLC memo on which it relies. That memo correctly rejected the case-by-case balancing approach that was employed by Juan, and instead emphasized that the existence of presidential immunity requires a categorical analysis. And they wrote specifically, thus, a categorical rule against indictment or criminal prosecution is most consistent with the constitutional structure, DERP, rather than a doctrinal test that would allow the courts to assess whether a particular proceeding is likely to impose serious burdens on the president. Okay, the judge doesn't get to sit there and say, well, I'm only going to give him a complete discharge, and he's not going to have any ongoing extended penalties, and so that's good enough. No, it's categorical. You don't prosecute our country's president. We just elected the guy. You don't prosecute him. Criminal sentencing undoubtedly imposes such serious burdens and cannot be allowed to proceed. And so thus, a sitting president or president-elect like Trump does not have to subject himself in any case to an individual judge's case-by-case garbage balancing of the burdens on the presidency. That violates the separation of powers because it makes the judge the president, and it violates the supremacy clause. And so therefore, Merchan is doing exactly what the OLC memo says he cannot do. And we think that you're going to reverse this. The New York court rulings on the first two questions are in direct and irreconcilable conflict with what you have said, Supreme Court. Their refusal to recognize Trump's immunity is erroneous, as we've already discussed. And there is going to be irreparable harm here if you don't act. So we need you to act quickly. We're going to suffer irreparable harm. It's already clear. Trump is already suffering this from the disruption and the distraction that this trial is inflicting. They've shoved this sentencing hearing right into his schedule on 5 days' notice, right in the middle of the transition. They are harming the transition by requiring all of this to happen. Emil Bove, Todd Blanche, these are Trump's nominees. Trump has to be taking the reins of the country after Joe Biden left him with a bankrupt treasury, multiple wars, and empty fire hydrants. These harms continue to increase as New York courts deny relief. Here's the details. Now, first, even general burdens of defending a criminal case is causing irreparable harm. Absolute immunity means you don't get prosecuted at all. Under absolute immunity, it is disruptive. That's why we have it, so that you're not disruptive. All these injuries are magnified exponentially when the threatened person is the president-elect. Trump is currently engaged in the most crucial and sensitive tasks of preparing to assume presidency in less than 2 weeks, all of which are essential to the nation. Forcing Trump to prepare for a criminal sentencing in a felony case where he's preparing to lead as the leader of the free world with inauguration in less than 2 weeks is undermining of vital national interests. And during this period, Trump is doing a bunch of stuff, communicating with world leaders, developing his agenda, selecting key personnel, coordinating with the outgoing administration, and more. All of this prosecution undermines his ability to do those things. These irreparable harms are further compounded by the abruptness and the extreme haste of Judge Merchan's decisions. After 6 months of post-trial litigation going through this for a long time, the New York court suddenly denied the last pending motion on a late Friday afternoon, set the sentencing 1 week later, not even allowing for pre-sentencing submissions from either Alvin Bragg or Trump. They're not even going to let the people prepare their memos and their briefs to argue for sentencing like every other case gets. Okay. They said Trump was not above the law, but they keep dumping him below the law. He has no due process, no presumption of innocence, no right to a jury by his peers. They don't even give him time to prepare a sentencing memo. Just show up and get sentenced. This is an extreme example of highly expedited consideration brought against the president. The 1 week period between the denial of Trump's immunity motion and criminal sentencing provides no meaningful window for appellate review at all, which, as we called out, was by design. In fact, it would be debilitating to our system of government if such a stay, which is regularly granted in ordinary criminal cases, were denied to a president of the United States who's raising immunity claims. But that's what New York courts have done, and they did it in error. And this is not even a close case. Your Honors, you don't need to balance the equities here. But if you want to balance the equities, here's how you should do it. All of the factors overwhelmingly favor us. The purpose of the stay that we're demanding is pending interlocutory review. It's to prevent the doctrine that you just handed down on presidential immunity. We want to make sure it has teeth. It will be futile if they can do whatever the hell they want. More fundamentally, forcing Trump to defend a criminal case and appear for criminal sentencing at the height of this transition risks disruption to national security and to America. And New York, their interest in sentencing Trump is only to satisfy their political motivations, and their desire to have a political victory should be accorded no weight whatsoever. So in sum, Trump's defense at the Supreme Court says this court should immediately order a stay of pending criminal proceedings in the Supreme Court of New York County, New York, pending the resolution of Trump's appeals. You should also, if necessary, enter a temporary administrative stay, if you need it, in order to afford time to analyze the underlying stay. Signed by D. John Sauer, smart dude, along with Todd Blanche, Emil Bove, and all three of those gentlemen going into the White House in some shape, form, or capacity. And so a very nice filing from them. The Supreme Court has responded to this. And the latest here is that we're coming back tomorrow to see what Alvin Bragg has to say, because this jurisdiction is in Justice Sotomayor's jurisdiction. She is a blue judge, but she's issued an order to Bragg to say, get us your response by tomorrow, January 9, 2025, and then we'll get an order shortly thereafter. So we're on track to get something decided from the Supreme Court late Thursday or fresh and bright and early on Friday, minutes before the sentencing. And so we're going to be here continuing to cover this case and the other Trump litigation. Thank you for subscribing, my friends, and joining as we do, because Friday we're going to be live streaming this and waiting for the stuff to break. And we'd love to see you here joining us as we do. All right, now we're not done yet today. We're staying with the Trump cases. We're just turning our attention now over to Florida. And the question is about the release of the Jack Smith report. And so let's discuss what's happening here today. Jack Smith and Merrick Garland are colluding once again to release the Jack Smith report. They want to get it out before Trump comes into the White House and takes over the DOJ, because then that report is not coming out. And so what are they doing? Well, as we've read in previous filings, they're trying now to bifurcate the report into two different components, Volume 1 and Volume 2. And they're saying that they can release Volume 1 because it relates to January 6th in the case in Washington, D.C. But in Florida, they'll withhold it because Judge Cannon still has jurisdiction in some capacity in that matter. So we're going to read through these filings because this is going to be their final effort to try to get this report released so that everybody can read it and they can smear Trump right as he's being inaugurated. But as we saw from Cannon, she's confirmed to us, Jack Smith is not a legitimate boy. He's not a real prosecutor. He was never lawfully appointed, and he stole $30 to $50 million. And so he cannot now use those ill-gotten gains that he wrote down on a book report to smear and to share across America. So the docket is very, very fluid at the moment. And you can see we've got a new filing that just dropped as we're recording right now. So let me show you what is happening. We had an appeal. We're in the 11th Circuit Court of Appeals, and Trump he's had his case dismissed already on the classified documents case because Jack Smith's illegitimate and because he got elected. And then we had a bunch of additional filings in this appeal, and a couple things just dropped. And what we see here is Jack Smith's team actually withdrew from this case back at the end of December before the year changed. Then we had a motion from the Trump crew to bar the release of the Jack Smith report. They filed their appeal and the responses are now coming in. So I want to show you Jack Smith's response, and then we'll look at this freshly dropped reply to Jack Smith's response, which is literally fresh out of the oven, as you can see here. So here is what Jack Smith said. And what is interesting about this is that Jack Smith is telling us what their strategy is. And so he is opposing an injunction that will stop them from releasing the report. He says, we don't need a court order to tell us we can't release this thing because, well, half of it we're not going to release anyways. Here's what they say. From Jack, this is Jack Smith's team, I believe. Let's see who's filing this. No, it's not. It's Mark Freeman. Jack Smith's team is off this case. So this is from the DOJ as it stands right now. Sorry for all the scrolling. Saying, the United States files this response in opposition to the motion for an injunction, saying defendants, called Trump, ask this court to stop Jack from submitting his final report and to stop Merrick Garland from making any portion of that final report available to the public. And as we were reading this, we were saying, well, what does final report encompass? Because Judge Cannon's case was only about the classified documents case. Jack Smith had two. What about the DC case? The DOJ says Trump's motion should be denied. And I'm going to say Trump, but it's technically Carlos and Walt. Now, as explained in more detail, there is neither any need nor legal basis for any injunction. Jack Smith has already transmitted the final report to the Attorney General, as permitted by the recent order, so he can send it to Garland. The final report comprises 2 volumes. This is their strategy. Volume 1 relates to January 6, the election case. Volume 2 relates to the classified documents case, which includes Walt and Carlos, as well as Trump and the classified documents handling. The Attorney General Merrick intends to release Volume 1 to Congress and to the public in consistency with the Code of Federal Regulations, which is the same stuff that they tried to invoke to appoint illegitimate Jack, and in furtherance of public interest in forming a co-equal branch and the public regarding this significant matter. Okay, so Volume 1, we're going to get, is what they're saying, but not Volume 2. But to avoid any risk of prejudice to Walt and Carlos, the Attorney General has determined, at the recommendation of Jack Smith, that he will not publicly release Volume 2 so long as the criminal proceedings remain pending. And so for the time being, Volume 2 will be made available for in-camera review for the chairman and the ranking members of the House and the Senate Judiciary Committees upon their request and agreement not to release any information publicly. Yeah, right. So they're going to give that right to Chuck Schumer, and he's just going to fax that right over to the Washington Post. This limited disclosure will further the public interest in keeping congressional leadership apprised of significant matters while the DOJ, the department, is safeguarding the other defendants' interests. Yeah, right. I think there's going to be a treasure trove of malfeasance in these reports. And they're under investigation for their misconduct in Florida already. And Florida is not the DC jurisdiction. So if they were committing crimes in their prosecution of Trump in Florida, part of me thinks that they don't want to release this second report because they might be prosecuted in Florida for crimes. They're like, well, we're not going to release that one, you know? Stanley Woodward is going in as an advisor to the White House. He's already got Jay Bratt's number for sure, as he should. And that all took place in Florida. So like, well, we'll just leave Florida alone. Let's not poke that bear. But we'll release the J6 case because that's in D.C. and any of our criminality there will just go to a D.C. jury. Something seems fishy. They're not releasing the classified documents report because they're concerned about Walt and Carlos's privacy. Give me a break. Not buying that for a second. Now, the essential premise of their motion is no longer relevant. They say Attorney General is certain to make the final report immediately public and thereby cause irreparable prejudice. But they say that's mistaken. They are not going to release it publicly. So they say the rest of Trump's arguments are without merit. They appear to urge that Garland should be enjoined from stopping the release of the final report, including Volume 1, which addresses an unrelated prosecution that is not against Walt and Carlos. They have no cognizable interest in that volume of the final report, and there's no standing that would justify asking this court, right? They say that, Cannon, you have no jurisdiction over that case, nor would there be any legal basis for any other interested party to seek to block release of volume 1, because that case is now dismissed, and there were no other co-defendants who might be hurt by the release of that document. They also say that Jack Smith unlawfully was appointed, but the United States has thoroughly rebutted that contention in its merit briefs that you then withdrew. But in any event, yeah, I know. The argument is irrelevant to the only action here at issue, which is the handling of the final report. No, it is not irrelevant. Hello. The final report was paid for by stolen money by an illegitimate prosecutor who should have never been appointed by Merrick Garland, who committed government misconduct by appointing someone who's illegal and paying him $50 million. The district court, in dismissing the indictments, did not purport to enjoin operations of the special counsel nationwide, and they couldn't have done so anyways. And so according to our own regulations that we write for ourselves, we're allowed to write a final report, and that's what we've done. What they now ask this court to do is to enjoin not just any action by Jack, but also to enjoin Merrick Garland to release the report to the public. As noted above and as discussed in more detail, Garland determined that he will not make Volume 2 publicly available, and that should end the matter. No, because Jack was still paid illegally to draft reports. And until we can disambiguate what Florida money was appropriated to get evidence that's going to show up in the DC case, it's all commingled. You can't separate the two. Trump's motion should therefore be denied, says Jack, or the DOJ. To avoid the potential need for further litigation, the U.S. respectfully requests this court make clear in denying the motion that its resolution should be the last word. The district court specified that its injunction barring the release of any portion of the final report, so she says nothing, including Volume 1, remains in effect. And so they're saying, Court of Appeals, the 11th Circuit, when you come back down on this, make sure you tell Judge Cannon that we can do this. So just tell us that, unless they go to the Supreme Court. We say, if the court agrees that no injunction is warranted, say so in an order and tell Judge Cannon, and then as soon as that order comes down, they're going to press send. Okay, and then Trump will have to go up to the Supreme Court, and there will not be enough time for the appeal to happen before the report is published. Ultimately, it'll go to the to the Senate and everybody, but they'll then publish it. So that is what just was filed by the government, and now, fresh out of the oven, we have the final reply. So again, we're in the 11th Circuit. This is Walt and Carlos, really on behalf of President Trump. They're bundled up together. They didn't win the presidency, so their case moves on, even though Trump's has been dismissed. They have a reply here to Jack's arguments, and here is what they say in response. All right, 11th Circuit, Florida. We now request that this court remand for a hearing in front of the district court. The government concedes that there is a substantial, if not guaranteed, risk of prejudice with public disclosure of the final report containing privileged material, grand jury material, or other evidence in an ongoing criminal case. But the government also suggests that this prejudice may be managed by disclosing the report only to the chairman and ranking members and only subject to redactions as the DOJ sees fit. Now, this is an improper attempt to remove from you the responsibility to oversee and control the flow of information. Your Honor, this is your criminal trial. This is not the Senate's Judiciary Committee's trial. They don't get to decide what evidence is valid or not. The place for that role is here. We don't want it in the government's hands. The trial court has an interest in preserving this. So our motion does not present, like they say, a straightforward legal question. Rather, the questions relating to with whom the report may be shared, like the likelihood of public disclosure, the appropriate level of redaction, those are inherently fact-bound in nature. They're best left to the trial court. So court, of Appeals in the 11th Circuit, you don't decide these things, but you send it back down. Although we dispute that the district court lacks jurisdiction to enforce its own orders, which is all they're doing here, this other case makes clear this court can relinquish jurisdiction to the district court for further proceedings. Now, the case law and the court rules do not contemplate the DOJ independently determining what may be redacted. The role lies with you, Judge, with Judge Cannon, not actually the 11th Circuit. This is a scenario where the district court, Cannon, is best suited to resolve these factual disputes. The government is saying all these things. We disagree, so we have to have a hearing. Why are they asking for a hearing? There's no way a hearing is going to be scheduled and completed before Trump takes office on the 20th. It's just a delay tactic, and it's a good one. This also is in the interest of justice and judicial economy. So the appellees are not back and forth before the court in a week asking to dismiss this case based on violations of the DOJ. And so rather than extend the process, the government proposes a scenario that would complicate and lengthen all of this. And so 11th Circuit, there are significant problems with what they're proposing here. In conceding that it must take some steps to avoid public dissemination, the government argues that it can mitigate that risk by disclosing the final report only to Congress. The DOJ's proposal does not adequately insulate against any prejudicial leaks. And see how they keep calling it the final report? They're not even calling it Volume 2 or anything. Nope. Whole thing's bound up. Sorry. The DOJ's proposal does not adequately insulate against the extremely prejudicial leaks, which have already been happening. And the government's proposed approach does not sufficiently address the threat that this becomes public. And it's the duty of the courts and prosecutors to prevent disclosure from happening. This should not be the first case in which this court, the 11th Circuit, preempts the district court from engaging in its own expertise. And so you cannot take this decision away from Judge Cannon. There is no way to restrain members of Congress from disclosing their opinions about the report or from disclosing the contents, nor is there a way to prohibit them from disclosing the materials to their staff or to prevent their staff from leaking. This country was founded on individual liberty, and those principles underlie our request. A hearing is necessary to prevent the overreach of the federal government to try to serve their political aims at the expense of an individual's right to a fair trial. And this idea of a middle ground removes the judicial oversight over the flow of publicity about this criminal matter and privilege matters that should never be made available to the public at all. The DOJ seeks to pillory the criminal defendants here using Jack's non-public advocacy. The government's parameters are unclear. What are the restrictions on members of Congress who can view this report? Can they publicly share their opinions? Are they permitted to discuss the case at all now that they've had access to confidential material that's going to shape how people view this case? Are they permitted to disclose their reactions to their staff? Can they commit war against the defendant's fundraising activities for their defense? Does public discussion of the report by the DOJ and members of Congress relieve the defense of its requirement to abide by the protective order? So can they talk about this case now? If this case is going to be tried in the court of public opinion, is the defense not at least entitled to an adversary process in that forum? These factual questions warrant consideration at a hearing, and that's what we need. And the concern about these leaks cannot be overlooked, by the way. Congress is a political body. Its individual members have political aims, and this is a political case. The government's assertion that disclosure to Congress is sufficient to safeguard Trump's rights falls short. Comments to a New York Times article showed that they leaked. This is an era where even a draft of a Supreme Court decision on abortion was leaked. The functioning of the political press depends on leaks, and if they occur here, there's not going to be any recourse for our defendants. And by the way, members of the House and the Senate Judiciary Committees are not entitled to access evidence in a pending criminal case, especially not privileged in grand jury materials, and there's no reason to provide that access here. If such access is to be provided, it must be done pursuant to a court process and after a hearing, not unilaterally by the DOJ. Well, we'll be good on it, we promise. In disregard of all the rules, policies, and more, a hearing, Your Honor, is essential because the government has conceded, they do need to redact some things. They've said they will do some of it, but we've reviewed their proposed redactions, and we deemed them insufficient to protect information that was obtained via grand jury subpoenas and that fall under criminal procedure rules. This dispute over the appropriate scope of the redactions is an issue of fact, and that must be resolved by Judge Cannon. Rule 6 contemplates this, and 6E3E does too. And it makes clear that disclosure should only be made in relation to federal criminal law enforcement, not for other aims. Their proposed disclosure is unrelated to their duty to enforce criminal law. It's a misuse of the grand jury process, amplified by the fact that Jack is not even authorized to participate in any of this. This situation doesn't fall within any approved disclosure capabilities, and so given the importance of grand jury secrecy, we know trial courts protect that secrecy, and that's why we need a hearing. It is not for the DOJ to decide what grand jury information must be disclosed or can be disclosed from Congress. That discretionary responsibility lies with the court. If any grand jury material is to be released to anyone who doesn't enforce criminal laws, there must be an adversarial hearing so we can have our say. The government says that the question about whether Jack was unconstitutionally appointed is irrelevant. What? This is wrong. Without the unconstitutional appointment, Jack Smith never would have had access to these materials that he's now trying to release. The special counsel never would have had access to the grand jury investigation, but for the unconstitutional nature of the appointment. And most importantly, the government pretends that it can argue the appeal on the merits in response to this motion, but that is not an issue presented in this motion. The issue is that the district court has entered an order. No stay has been sought from that order, and it concludes that special counsel Jack had no authority to act in this prosecution. That settles the matter for the purposes of this motion, and the government cannot now rely on its exclusion from the case as a basis to be excluded from judicial review. The government says that Garland could have just hired the special counsel as a staff member, but that is not what he did. The final report stems from an unlawful appointment. It was prepared unlawfully. It is thus a legal nullity under the binding order issued by the district court in this case. It is not subject to the Code of Federal Regulations, and there is no obligation at all to release the report. Aside from the legal problems related to disqualification, Jack, the plain text of the regs say, and it does not provide for the release of a report while a criminal case is still pending. The regulation says that the Attorney General will notify the Chairman of Congress with an explanation and blah, blah, blah. The investigation is not concluded here because the criminal case is still pending. Now, the DOJ is attempting to find a loophole by suggesting that because Jack was disqualified, he may disclose all to Congress, who is now outside the reach of the district court's ability to impose gag orders, while the criminal investigation remains ongoing. But the DOJ should not be permitted to exploit that loophole. And it certainly should not be permitted to do so without a hearing and any oversight from Cannon. And a separate section of the rules explicitly contemplate that there will at times be need for secrecy, even where, unlike here, the criminal investigation has concluded. This case presents the unprecedented scenario of attempted release to Congress while the investigation is still ongoing. Jack is really kicking himself for adding in Walt and Carlos as co-defendants here. He's like, oh, dang it. Such a scenario is not contemplated in the regs and thus demands court oversight, especially given the pending nature of the case. So where the special counsel has been improperly appointed, this is Trump, Carlos, and Walt's defense, as in this case, the Attorney General lacks all authority, premised on either on applicable regulations or independently of those regulations, to transmit the report to Congress or to the public. Neither the U.S. Code nor case law cited by Jack empowers the Attorney General to release a report that was prepared by an unconstitutionally appointed counsel. Indeed, the unconstitutionally appointed counsel did not even have the authority to author the report, and doing so was directly contradictory to Judge Cannon's order. Jack read the district court's order as narrowly as possible, and proceeded to act as if he were validly appointed counsel in this matter when he submitted it to the Attorney General. That level of disregard and lack of adherence to Judge Cannon's order is pertinent, and it emphasizes the need for Cannon to be involved. The government's response leaves open questions about the contours of the government's proposed middle grounds and substantial areas of disagreements between us about what can and cannot be shared. The judicial branch, not the executive branch, must resolve these questions. They bear directly on a criminal matter in your district. And so the government says that a remand back down to Cannon would cause further delay. We don't want a hearing, the government says. No. No evidentiary hearing, just let us release this thing. But the government does not identify any urgency so great that Cannon cannot hold a hearing. It's going to take a day, and it is essential to protect the due process interests. It might take a day, but maybe that day is on January 21st. Any delay caused by such a hearing would be de minimis, okay? Nor would a remand case be any emergency. It's a threat to the defendant's fair trial rights. It's already been quelled by your restraining order. The only counsel in this case now claiming urgency is Merrick Garland. But the government's brief does not explain the urgency. Well, the urgency is they're running out of time to make their political attack happen. The Attorney General is an office, not an individual. It's going to be there when Merrick goes. Hello. It will continue in perpetuity. Unfortunately, the urgency of political activity is a fake urgency. The government acknowledges that there are separate considerations with respect to Volume 1 and Volume 2, and they get very cute and clever about this. Like, well, there's like two parts to it. Dividing it into subsections, proposing different conditions of release. As the government acknowledges, Trump's counsel have not even been granted access to review Volume 1. Without the review, we cannot even determine the nature of the materials contained inside, whether they bear any relevance to their respective constitutionally protected defenses, and to the extent that there's overlap between the two volumes, due process says we got to review each one and lodge our objections accordingly. And we got to do that in Judge Cannon's courtroom. And so for those reasons, Trump, Walt, and Carlos respectfully request the court remand back down to Judge Cannon for a hearing, and in the meantime, enter an order precluding the United States, its officers and agents, including Smith, his team, Garland, and the DOJ, from issuing a final report. Dated January 8, 2025. And you can see a little bit of a strategy shift there. Well, let's just go back down and have a hearing about all this. And it's going to take a bunch of time, and then Cannon can weigh in accordingly. And we'll see what happens. I think that there's a strong possibility that something comes out somehow. These people are going to scramble to leak it, or maybe Chutkin will, I don't know that she can say anything because her case is dismissed. We'll see. We're going to keep our eye on it, but we're now fully briefed on this, so we're waiting on a result from the 11th Circuit, and we'll see what they do. We'll be back here tomorrow to get into that, and so thank you for subscribing and joining as we cover this case and more. And now, my friends, let's listen to a couple video clips. Pete Aguilar, who is someone who used to be on the January 6th committee. You can see this is shared over from our friend Kyle Becker, N.A. Becker, over on X. Shared this clip via Breaking 911 showing Pete Aguilar is still committing this heinous, scandalous lie that there were AR-15s and guns and weapons inside the Capitol. There was like one guy with a concealed carry gun that was not even brought out. And they say this was an insurrection? What?
Well, I have the same question to you, but I wanted to add something else. Sorry, Trump will have press conferences. He did have one, but he also made an allegation that there were no guns on January 6th, bolstering his support for pardons, that Hezbollah may have played a role in January 6th, and that the person shot trying to enter the House chamber was shot for no reason at all. You're on the committee.
Her name is Ashley
How do you
Babbitt.
respond to what seems to be the rewriting of that day?
Well, this is not new for Donald Trump. He is trying to rewrite history and suppress the truth. That is exactly why he does not want the special counsel's report released down in Florida, and it is exactly why he continues to spread lies about January 6th.
It's because it's a fake report from an illegal prosecutor who was never lawfully appointed. So why should he be allowed to go in, spend $50 million, create a lie report based on evidence he should have never had access to, and publicize that?
But let's talk about the weapons that were on campus on January 6th. People were arrested with bear spray, and people were arrested with
water
tasers
bottles.
and
Yeah, one of the Proud Boys charges was a water bottle hit somebody in the head.
brass knuckles. People used flagpoles and fire extinguishers to beat police officers.
Yeah, and Ray Epps was that dude who was holding that sign and shoving it into cops, and nobody did anything about that. So they're going to continue to do it. I'm actually for it. They can just keep talking about January 6th constantly because it makes them look fat and idiotic. Here's one example of that from Adam Kinzinger, who is just getting chunkier by the day, man. I don't know what's going on, but as soon as he left Congress, apparently he doubled his caloric intake.
Says that he thinks
all right,
Biden
so fast forward.
Because I didn't do anything wrong. Okay. I mean, look, it's...
Yeah, you did. You were on an illegal committee. Look at that face. You know what you did there. You know what you did. You were on an illegally constituted committee, and you were palling around with Liz Cheney, colluding to make witnesses perjure themselves under oath to create a fictional facade and narrative to try to take out Trump during 2024's election. And now Trump's coming in, and the people like Benny Thompson are hinting that they do want a pardon, in fact.
If Donald Trump wants to come after me, you know, look, do I want him to come after me? Of course not. But if he decides to, I'll be twice as much of a pain in his backside because I will, from my cell in jail, continue to remind the American people that this is not the country we live in. This was not the country that the...
Okay, offer accepted. You can do that from your jail cell. We'll be fine with that. Go in there. You can do your little stupid speeches from behind bars in solitary confinement like you did to the J6ers. We'll see how you like it, and we'll see who is out on the outside standing up and speaking out for you. Probably not going to be many people because we know what you did. All right, so that's Kinzinger, my friends. And of course, we'll keep our eye on him as well. But now, my friends, it's time to hear from you. And so if you're just joining us, quick recap on what we talked about at the start of the show. We went through Trump's sentencing, and his team is now knocking at the door of the Supreme Court. Very good filing. A lot of the same stuff we've seen in his other appeals. But what was so nice about this is they're showing the Supreme Court their own words. You said this is how it works. We're operating according to your rules. They're not. Can you please step in and do something about this? And so tomorrow we're going to have the response from Bragg and his team. And then we might even get an order late in the day or early Friday morning because sentencing is coming on Friday. It's going to be a jamming week. Okay, so we talked about that. Then we went through the Florida classified documents case. And here we're on appeal to the 11th Circuit, fighting to stop the report from coming out. Jack Smith wants the 11th Circuit to give them permission to do that, at least as it relates to Volume 1, which is the J6 case. And then, of course, we've got questions about the classified documents case, which they'll probably not release officially, but then it'll go to some Democrat on the Judiciary Committee, and they'll copy and paste the whole thing and release it to the New York Times. So some good stuff, a lot of legal filings happening right now. The clock is ticking. Sentencing is still currently scheduled for Friday. And so, of course, we'll be back for that one. And we'll be back tomorrow at the regular time. So, my friends, thanks for being here. I, of course, want to hear from you, see what you say all about this. I also want to remind you about our inauguration watch party, which is happening January 20th to ring in the historic inauguration of President Trump. We're doing it live in person in Scottsdale, Arizona. Tickets are available now. $100 includes your food, includes the venue, includes the fun and the friendship, all included in that one low price. So check it out, watcherlodge.com. Come get your tickets. It's going to be fun. I ordered some cool stuff yesterday, and I think we can say we have 3 highly experienced females who are now helping with this program. So it's going to be much better than it would have been otherwise. So we're looking forward to that. And they've got some good stuff cooking. It's going to be a lot of fun. We'll have a special guest or 2. We'd love to see you come join us. If you're in the Southwest and you can't make it to Washington, D.C. for the inauguration, come to the Mar-a-Lago of Scottsdale and celebrate with us in Scottsdale, Arizona. Watcherlodge.com. We'd love to see you there. They're fun, okay? They're a lot of fun. These things are, we get to meet each other. It's like, what's up? We love each other. It's so great. So come and join us. All right. If you can't make it, We're talking about a digital ticket. We're going to live stream a portion of it, but then maybe we'll do like a backstage ticket, just let the stream run and people can go and say hello and do whatever. So we're figuring it out, but it's going to be fun. WatchOurLodge.com. Thanks for joining us. All right. And so let's see what you say about this, my friends. I saw some very nice and generous donos come in. Welcome aboard to our new membos who are joining us. Of course, thank you to our amazing mods. What's up? Donut is here today. Clipping for us. Carrie B. K. Bean in the house. Clipping for us. This morning we were talking about Chinooks in the air. Somebody's saying there are Chinooks flying around the top of their houses, sniffing fog and stuff. Things are getting wild out there. And we're keeping our friends in California in our thoughts as that entire state smolders. We talked about that this morning on our members only stream, some really horrendous footage out there. We got Will Crump here says, can or will SCOTUS sanction Juan Mercan for acting in open bad faith by rusing to label the President Trump a convicted felon? So many glaring errors there from Will. They could. I don't think that they would. More likely than not, they'll just scold him and correct this heinous attempt. I don't think that they'll sanction him or anything like that. I think they'll leave that to the states, but the opinion will speak to itself. If the Supreme Court comes back down and backhands Mercan, that's going to be, a sensitive mark on him, but he'll take it like a badge of honor. Okay. He'll take it. He'll ride that for the rest of his career in New York City. So thank you, Will. I don't think that they will do that. Hopefully they just do what we want them to do and just put this whole thing, bring it to a halt. Rick Donner says, OMG, Biden was talking with Newsom. Says, people found out today their homes probably burned down, but there is good news. Today, I'm a great-grandfather. I think I might have that clip handy. I saw that earlier today, and it was pretty painful. Nobody was clapping. It was a very awkward moment. Yeah, here it is. Got this one saved up. Here it is. Clip coming to us courtesy of Matthew Keys. Matthew Keys Live. What's up, Matthew Lee? Thanks for the clip. Shared this one.
We got notification yesterday their home was probably burning down. Today, the parents are maybe still standing, I'm not sure. But the good news is, I'm a great-grandfather as of today. I have a granddaughter, and a baby girl, a baby boy. So I remember this day for a lot of long reasons. Thank you, Brett.
It's very amazing.
Dude's totally gone.
Thank you so much, everybody. Thank you, Brad. Thank you so much. Make your way out. Make your way in the park. Please go this way. Thank you.
Really sorry your house burned down. I know you've lost everything in your whole life, and our government has been promising you that we're competent, and then we found out there's nothing in the fire hydrants anymore because even though we live on an ocean, we have no water. But anyways, beside all that, I'm a great-grandfather. Thanks, Joe. You can leave now. Get the hell out. Even everybody in there was like, are you nuts? Duh Hook. I recall Jack releasing a report from J6 and the case before the election. You read it on the show. How is this report different? It's not much. And we objected to that too, right? That was his big appendix in his dossier. That was his pseudo report. But I don't think the report is going to be that much different. I mean, it'll be much bigger and less legally compliant, so he can say whatever he wants in there because it's just his opinion in his report, and he'll be less subject to the confines of legal writing. But it's the same, right? He's trying to leak and release a bunch of stuff. So I think factually, it's going to be a lot of overlap there from DeHook. Thank you, DeHook, for that great question. And I don't know that Trump is necessarily, like, Trump doesn't want it on his record to be released, but I don't think that there's any information in there that we're going to be like, oh my gosh, we were wrong, or Trump, he didn't do anything wrong. They made it all up, and they've been enjoying themselves writing their little reports for the last however many years. So I'm not concerned about the report being released per se, like because of what's in it. I just don't want them to have that victory. Like, how about you waste all this time and money and you don't even get a conviction, and then you don't even get a report? Man, you suck at everything you do. Jack Smith, remember all those lunatics like Andrew Weissman and Conway? They had like Jack Smith fever. They were like admiring his foot-long hot dog or whatever during his lunch break. He loved footlongs. Like, we know you do. Okay, we know. And they couldn't let it go. And then the guy is the biggest loser you've ever seen. He accomplished no convictions at all and may not even get a report and is not even a real boy, for crying out loud, and is probably going to be prosecuted, hopefully. Lenny Malley. What's up, Lenny? Thanks for reminding everybody to smash that like button. We appreciate that, Lenny. We got a new baby in the house. 2 babies. That's what 9 plus 9 is. 18 months. Reminding myself on that one. Thank you for that. Kaiser of Third Age, 18 months as a membo, man. We've seen some serious stuff together. Good afternoon, Robin Watchers. Have a good 2025. You too, Kaiser of Third Age. I hope it's good and even great, hopefully. Sheila the Pooh is bringing in new membos. Thank you, Sheila. Great to see you. Hopefully your New Year's off to a good start. Bringing in Christy Lamoli. Maina Salt is here. We got Dog Backwards is God, Shirley Watts, and Cindy C. in the house, courtesy of Sheila Pooh. Thank you, Sheila Pooh. A million hugs to you. And even another comment says SCOTUS needs to not only approve the stay, but needs to throw out the whole case. Yeah, and they can say, we issued an order. He violated our order. The order is to remand this case with an order to dismiss. Should happen. We'll see if it does. Hey, Mock Schnell. Good to see you, Mock Schnell. Says, well, it is the new year time to gift some membos, as Rob does such a great job. Thank you, Mock Schnell. And you non-members deserve a chance to listen to him on the members morning feed. We do good membo streams, man. We have a lot of fun. We talk about stuff. It's a little bit, it's a little bit more casual. We still have a bunch of stuff that we get to here that we just can't get to here. And it's great. We get to meet people. It's great. Thank you, Mock Schnell, for being an amazing membo. And Mock Schnell means more speed. Is that right? That's German, right? Mock Schnell, what's up here? I had a PE coach who used to yell that at us when we were running around. Was he a Nazi? I don't know. But he used to yell that at us. We were running around laps. Mock Schnell! Mock Schnell! He's screaming at us. Kind of this big overweight dude. Maybe he was a Nazi. I don't know. Sean Lucifer, what's up? We got Woozy Susie Cocoa Puff coming in. Fruit Fly Sadist. That's an interesting one. Fruit Fly Sadist. All right. Deep Surface. There's probably good videos on those. Ryan, Jesus Freak, Gizmo.net is here. M. Craigs, Cardinal O'Flanagan in the house. Top of Mind. We got Dissident Porcupine, Guitar Man in the house. Maina Salt is saying woohoo. William Lyons, Kid Savell, My Bet, Old School. Julia Arnold, Grandma Goo is here. Daughter of Kings, Rita. Amazing. Premier Detailing Auto Spa. And Gate Watchers in the house. Gate Watchers. I like that. Thank you for all becoming membos. And thank you to Mock Schnell for bringing them in. Appreciate you bringing 20 new membos in, Mock Schnell. Very nice of you to do that. Hey, Zhang Shin. Thank you, Zhang Shin. Thank you for becoming a supporter. Grab the members only stream from this morning. And then we'll be back tomorrow with members only morning stream and then the show at the regular time. This old guy says Judge Mercan needs to be impeached and investigated after his impeachment. This judge out Chutkins. Judge Chutkin. Yeah, that's a lot of Chutkining, man. It's really bad. If you're worse than Chutkin, it's bad. And Mercan is worse than Chutkin. You're right. Chutkin at least abided by what the Supreme Court said. As bad as she was, she said, oh, crap, I have to stop it. She stopped the case. Here's the dictionary phrase, tendentious. Turn to your neighbor and say, tendentious, expressing or intending to promote a particular cause or point of view, especially a controversial one. That was our $3 word of the day. Thank you, Donut. Rivka, the Jade Gamer, says, isn't it DOJ policy not to give reports on active cases to Congress? I think that's what their argument was. Yeah, you can't do it. And you can't bifurcate these things either because they're commingled and they're muddled together. So we have to have a hearing and we can disambiguate the two. But yeah, I think that even came up in their filing today because there's no assurances that they won't leak and they need the court to be the gatekeeper. Crash says, these 2 book reports are already in some anonymous DOJ malefactor's Dropbox. Totally. Confidentiality and privilege be damned. Waiting for the best time to disseminate to the rags of the MSM. I'm for releasing the reports, plural, and giving me a full opportunity to see the criminality of Smith, Brat, and Highlighter Girl. I'm an adult. I can figure it out. Yeah, I'm kind of like I think the benefit of not having the report come out is that they lose even more badly, which I'm for. It's like all of their fruits of their labor, and they're not even going to get a report out. That's how pathetic you guys were And you did that because it's happening really because you charged 2 co-defendants who should have never been charged. So you made a mistake on that one. Good job. And you illegally appointed the wrong person. It's like you guys are just idiots. Well done. So you can't, but the report, I think part of the reason why they're maybe okay with not releasing the Florida report is because they know it might expose them and show how little is there. And you'll be able to compare and contrast the Florida report with the Robert Hur report and see those two things. Not that you would take anything even in Jack Smith's report at face value. I also wonder if they even have that report done. Like is it even done? Yeah, but I'm with you, Crash. Nothing in the report freaks me out. I think that it might be just more evidence of their corruption on full display. We say, wow, this is terrible. And it might actually bite them in the butt. But I also like them not having any victories at all. Like they can't even get your report out. Pathetic. Crash says, Kinzinger is looking like a man who's been hitting the juice more than once. You think that's what it is? You think it's that steroid face kind of swelling up all over, a little HGH going on? Hey, what's up, Rob? Says, Your Honors, we redacted the important information from the report to protect individual. We redacted the grammar problems like the ones Walt and Nada did. We didn't want to lose our jobs. From Rob on Rumble. Thank you, Rob. Hey, Sheila the Pooh is bringing in 5 more membos. Thank you, Sheila. Look who's coming in. Michael LaValle. Amazing. Good to see you, Michael. Funkadelic. Lisa T. Welcome. An internet loser. You're not a loser to me. Sam E's joining us. And Sheila Pooh, thank you for bringing in 5 new membos in the house. Let's see who's coming in here. Voice of the people. What's up? The voice of the people should be heard. No doubt about it. Voice of the people, what's up? Off-label podcast right next door on YouTube. Bringing in 10 membos. Thank you, Voice, for doing it. We got Joanna McFall. Augustus Tiberius is here. We've got J.H. Schwalbach, Dale Davis, Brian Bentley, G. Tria, Jen McDavid, Greg Erickson, William Selman, Kevin Bodeman in the house, courtesy of Voice of the People. Thank you, Voice, for bringing in our new friends. Uncle Bozy says, I hope Sotomayor rules in accordance to the Constitution, and it is honorable enough to put her political views aside. Well, I think what she's ordering is just a response, and then she'll take those responses to the court, and then the court will issue a view on that. And I think, what is the rule? It's like 4 are needed for a stay. I always forget what the exact number is. A certain number of judges are needed for a stay. It's 3 or 4. I think it's 4. So it's only up to Sotomayor. Why? No, she just runs the circuit. So she's just like the main. She's not the only decider. They bring it to her, and then her team handles it. She assembles the briefs and then takes it to the court, and then the court will decide. Philip Coggins, here's an amendment proposal. New POTUS VP and Congress are sworn in on December 1st. No lame duck session. Only business allowed is confirming new POTUS appointees and certifying the Electoral College. From Philip Coggins. So, Philip, you're kind of picking up what I think they were figuring out after the Civil War. I mean, the Civil War, I think our inauguration used to be in March, right? And that allowed a lot of time and a lot of things to happen. So, like, after Lincoln got elected, the whole country was basically apart as he was coming into the office in March. Like, oh, what the hell? It's all breaking apart right now. So I think there was an acceleration after the Civil War, right, to actually accelerate it to create less of that problem. So we have less time, so we can transition more quickly. I don't know. Can they do it in 3 weeks? Can you transition in 3 weeks? It's quick. Eugene Sand says, please tell me that there are lawfare kings on Trump's side who have a stack of arrest warrants ready for January 20th and then gag them all before retrial. Yeah, I think that is right. Eugene Sands. I think that is right. There are lawfare kings. There are a lot of them. There are Todd Blanche, Kash Patel, Emil Bove, Stanley Woodward. They're all going in. They're all going in. And let's see. Here's a comment about requesting emojis. So Just Rhonda is our purveyor of fine emojis, and she does a great job assembling emojis and sending emojis to us, and says that she is sending 40 to 45 emojis working on sending those over, hopefully by next Monday. And so, my friends, if you're extremely excited about getting these emojis, have some patience because they will be coming and implemented soon. And we love Just Rhonda for assembling them for us. Thank you, Just Rhonda, for being our purveyor of fine emojis. Uncle Bozy says, does Jack Smith remind anyone else of Rasputin, or is it just me? Does Jack Smith remind anybody else of Rasputin, or is it just me? Yeah, a little bit. Jack Smith, he reminds me of a deranged thug. Here's one from Bill Dozer. Says, does Trump have to show up for sentencing, and should he? So as it stands now, yeah, he does need to show up, but he can do it by Zoom. So it's either in person or by Zoom. Should he? Yeah, probably. If there's a court order for him to show up there. I think if he doesn't show up, then he's giving them, like they're kind of baiting him. I think they would prefer he does not show up so that they can say, see what he's doing and all this crap. So I think he probably should show up. 10 days later, he's going to be the president. And then unleash hell. And I'm not even joking about that. And I would fully support it, by the way. Like, if they're going to violate the judiciary to go after their political opponents, I'm totally fine. Like, if they're going to kick Trump in the nads, he can kick him right back in the nads twice as hard, and he'll be the president. So I'm totally in favor of it. And I'm serious about that. I'm not in favor of weaponizing the Justice Department, but these people, and I'm not saying it's weaponizing anything. He should prosecute them for breaking the law, and they should be punished to the maximum extent of the law. He's not doing anything illegal, but a total focus on what they've done. And the people elected him into the position to do it. So I'm totally fine with it. I don't think it's anything like targeting or retribution or your enemies or anything. These people have gone at, it's like you give the victim of the crime the power to be the prosecutor. The American people just did that. So I think that's probably the better play. Just show up, eat it. Hopefully the Supreme Court makes it moot. Okay, that would be ideal. Supreme Court makes it moot, but if Trump doesn't go to the sentencing, then they're just going to say, well, you're in violation of a court order, and we're going to issue a warrant for you. And then things really escalate. We've got this new conflict that I think might even be more distracting from his new term than the sentence would. So that's how I'm sort of seeing it at the moment. But I'm hopeful, and I actually think there's a moderate chance the Supreme Court stops it from happening. We hope they do. But then the full power, the full office of the presidency should be brought to bear upon the people who broke the law and victimized him and these people specifically. Merchan, everybody involved. Former, if Smith was unconstitutionally and illegally appointed as special counsel, would he be ineligible for prosecutorial immunity? Absolutely. Yeah, he's not a real prosecutor. He's not a real boy. He's at the top of the list, man. And especially once he was on notice, okay, once the court dismissed him and disqualified him, every action after that fact, after he was on notice, was in violation. I think it's theft of money. If he collected one paycheck and the government paid him one time after the DOJ dismissed him for the prosecution of Trump, rather, okay, maybe they keep him on in some other capacity, but they were paying him to prosecute Trump after a federal judge says he's illegal. That should be a crime. Lisa Wilson, what's up? Welcome aboard as a supporter. Great to see you. Welcome aboard. We'll see you tomorrow on the members only stream, and hopefully you grab this morning's stream. SD Gold Star Mom says, hello, friend. Your box of goodies is shipped. Should be there by the 14th from SD Gold Star Mom. Perfect. In time for our inauguration party. Is this the rhubarb? All right, my friends. The 15th may be our final show. If I die or not, we don't know. Hey, Rob is here. How much wood would a woodchuck chuck if a woodchuck could chuck woodchuck? A lot. Chuckin'? Like chuckin'? I don't know. Thank you, Rob. Good riddle. Hey, More Here is bringing in 5 more here. What's up? Tina Childress is coming in. Kimberly Ferris. Kevin is here. Cognitive Dissident Jane, welcome. And BW804 gifted membos courtesy of More Here, bringing in More Here. Thank you, More Here, for doing that. Good to see you. Uncle Bozy says, there you go. Yeah, it's not weaponizing. Hello. It's holding lawbreakers accountable. Yeah, exactly. It's not. And I think Yeah, I'm saying if Trump focuses on these people, I'm fine with that because they're highly visible criminals. So they should be made an example out of that, right? They said no one's above the law. They tried to make Trump an example. So if he makes an example out of them, I'm fine with it. And it's legitimate because they actually broke their oath of office and they've committed crimes. And we're looking forward to seeing them held accountable, just like they wanted Trump to be held accountable. Okay, so my friends, it's been a beautiful stream. Let's see if we got any comments over on X. Fred Pedamonte says, Mercan is an acting judge, but oddly, he was assigned to this case. He got the Trump case, the Trump Organization case, the Steve Bannon case. Yeah, they just kept giving it to him because he's their anti-Trump hatchet man. It is what we've got. Hey, Rick Donner is saying he's going to send some rhubarb antidote. What is that? Like a chocolate milkshake or something? I don't know. What's the opposite? Thank you, Rick Donner. The opposite of rhubarb pie would be like a steak, maybe? Pinochet's helicopter tours. Oh, it's Pinochet. He's back with his very exciting tours. You can't weaponize something already weaponized. I hope that Trump targets his enemies with all the fury of Allah with the strength of 1,000 suns. Yeah, me too. Me too. And I'm not Muslim, but me too. I hope so too. And I can endorse that. Thank you, Pinochet's helicopter tour. Some of the funnest rides you've ever been on. Black Dragon. What's up, Black Dragon? Thanks for becoming a supporter, Black Dragon. We appreciate you joining us. Of course, we're going to have an amazing members-only morning stream tomorrow when we come back for our members-only morning stream tomorrow. But, my friends, until then, whoa, Black Dragon just brought in 10 new membos. As we're waiting for those membos to be gifted out, let me say thank you to our amazing mods and our meme smiths. Also, our Spotlight supporters, Mitchell Townsend, MJ Powell, and Anthony Petticini are Spotlight supporters over on YouTube. And we're grateful for their extra love and their support of the show. Thank you very much for those donos. We also want to thank our mods and our meme smiths. K Bean in the house, Donut, Mind Me. We got Carrie B, Playing Hooky, Dog Digger, and Janek modding the fort down for us, keeping things nice and beautiful. Get your inauguration tickets, my friends. Join us for the historic day in the Mar-a-Lago of the Southwest in Scottsdale, Arizona. The DC in Arizona. Come join us. It's going to be fun. Get your tickets. WatcherLodge.com. WatcherLodge.com. We're welcoming in new friends, courtesy of our friend Black Dragon. 10 membos. Here it is. Black Dragon, thank you for this. Black Dragon, man, such a cool name. Suzanne B. Seek and Destroy Juggalo News Audit. Welcome. Colin Lyon. Donnie Brewer, a.k.a. Brew Sky AZ. Chris Sawyer is here. Timothy Farrelly. What's up? Laurel Sharp. Good to see you in Columbus, Ohio. What's up, Laurel? Miko Starr, Steve Sayers, Stephen Farrington, and Ryan Vintage. Gifted membos courtesy of Black Dragon in the house. Thank you, Black Dragon, and welcome aboard 10 new friends. We'll have our members only stream tomorrow on Thursday. Membos on YouTube and locals. We'll see you there. Otherwise, my friends, we're going to call it a day right there. We're going to leave it there. We are coming back tomorrow for the regular stream, and we'd love to see you here. And we'd love it if you would invite someone you know or love to come over here and join us so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.